These people, I think we would say, is one to watch. And of course, I mean that in a positive way. Now, following our main speakers, who will speak for probably around 45, 50 minutes, my colleague and now acting dean of the Faculty of Law, Professor Fu Hualing, also Warren Chan Professor in Human Rights and Responsibility, will be providing some comments on the issue and on the two main presentations. And if there's time remaining, I may also add a few comments. And hopefully we'll also have some time for Q&A. All right. So with that introduction, may I please invite Hectar Pun to give your presentation.
Good afternoon, good evening, everybody, and thanks for the kind introduction of Professor Yang. Without further ado, this is what we are going to talk about tonight. This is the roadmap for today. I'm going to talk about the introduction to the extradition or surrender concept, and then following from that, I would briefly introduce the existing mechanism under our law. And then Anson will tell you his understanding of the bill and also the implication of the proposed bill by the government. Then I will follow him by suggesting some alternative approach instead of having the bill being passed. What are the options for the Hong Kong society to look at if possible at all? So this is the roadmap. I'm sure that so for part A, I'm going to speak on two matters. One is what is surrender or what is extradition. Extradition, of course, I'm sure that you know, is a formal, I emphasize formal surrender by one country or jurisdiction or territory to another one based on, most of the time, reciprocal arrangements, partly judicial and partly administrative, which I will also explain later, of an individual. So we try to arrange this individual who is being accused of and sometimes has been convicted of a criminal offense, which must be a serious one, which was also committed outside the territory of the extraditing place and wanted by the jurisdiction of the requesting state. So this is basically what we understand to be extradition. So why do we use the word surrender in Hong Kong? There's a reason for it. The reason is because extradition is only normally used or reserved for the delivery of individuals belonging between sovereign states. So one country wants another person from another sovereign state. We use the term extradition. However, in Hong Kong, we use the term surrender, and we use that term instead of extradition in our Fugitive Offenders Ordinance, Cap 503, to reflect the special status of Hong Kong SAR, not being a sovereign state, but a non-sovereign entity with an independent judicial system. So this is why we have these different terms being used. So the second part is about the Taiwan case, which I'm going to very briefly touch upon because it is the foundation of today's discussion basically. So the Taiwan murder case is a sad case which happened last year. So in early 2018, there was a case in Taiwan in which a Hong Kong permanent resident was suspected to have murdered another Hong Kong permanent resident. So one Hong Kong people killing another people, but not in Hong Kong, in Taiwan. And then the suspect returned to Hong Kong. So in this case, the suspect cannot be subject to surrender arrangement because under the existing law, Taiwan was excluded from the definition of the law. So despite the request made by the Taiwanese government, Hong Kong government under existing law is not able to pass this person back to the Taiwanese authority for a murder trial. And I will explain that later. But this is the factual background. And this is the judgment when Mr. Chang, this is the suspect, Chang Tong Gai, when Mr. Chang was dealt with by the Hong Kong Court of First Instance in Hong Kong a few days ago. So the fact is this: in the morning of the 8th of February 2018, the accused and Mr. Pun, Ms. Pun, she was the victim. They depart Hong Kong for Taiwan. After a few days, after 9 days, in the small hours of 17th of February, Ms. Pun informed her mother through WhatsApp that she is coming back to Hong Kong. However, the mother didn't receive anything or any further information from the daughter. And on March the 5th, the mother made a report, a missing person report to the police. So the accused, he himself came back to Hong Kong on the date as expected by the mother, but the daughter didn't come for obvious reason because she was killed in Taiwan. After about a month, the police interviewed Mr. Chang, and Mr. Chang confessed during the interview. He admitted that he killed Ms. Pun in Taiwan. Therefore, he was arrested by the police for different offenses, including murder and handling of stolen goods. So he was then later on charged in Hong Kong by the Hong Kong authorities for 4 charges relating to money laundering, because he used his credit card back to Hong Kong, used some of the money obtained in Taiwan or in Hong Kong. So a few days ago, on the 29th of April 2019, he was sentenced by the court of first instance to an overall terms of 29 months imprisonment. Obviously, there was no murder charge possible in Hong Kong because all the charges are charges relating to money laundering offenses. So according to my calculation, which I think have some, it might vary 1 or 2 days, but that is more or less the situation. He has been detained since March 2018, and because he was subject to 29 months imprisonment, so he might be released in October 2019, the earliest, taking into account the 1/3 remission for good behavior inside prison. So he might be released in October 2019. So this is the background to our today's discussion. So it takes me to my next part, the existing mechanism under Hong Kong Fugitive Offenders Ordinances. So the existing mechanism, they are 4 parts which I will discuss today with you. The first part is about the ordinance itself and the procedure and the restrictions under the law on surrender. And lastly, the most important part in Part B is the limited role of the court, the limited role of Hong Kong court in dealing with this kind of cases. So you see under Cap 503, the Fugitive Offenders Ordinance, the background is this. In 1997, because of the resumptions of sovereignty, or for the preparation of the resumption of sovereignty, the Fugitive Offenders legislation as applied to Hong Kong at that time, and the arrangement for the surrender of fugitive offenders based on bilateral or multilateral treaties, which the UK government has signed for Hong Kong and has extended to Hong Kong, will lapse. So they need to find a way to continue the mechanism in 1997. So the Hong Kong government, obviously at the time, with the agreement of the Chinese side in the joint liaison group, they proceed to negotiate a network of bilateral arrangement. All of them are actually bilateral arrangement between 2 parties only for surrenders of fugitive offenders, which would remain in force after the 1st of July resumptions of sovereignty. So that was the background for the need of a new offender, fugitive offenders ordinance, because all the old bilateral or multilateral agreement would lapse because those agreements were signed by the Hong Kong government, by the UK government on behalf of the then colonial Hong Kong government. So the Fugitive Offenders Ordinance was then enacted in April 1997 to provide for the statutory frameworks for the surrender or the continuous surrendering of fugitive offenders after 1st of July 1997. So the ordinance provides for the surrenders to certain places outside Hong Kong or persons wanted for prosecution or for imposition or enforcement of sentence if he has been convicted in respect of certain offenses against the law of those places. So this is the long title of the law enacted in April 1997. So what is more important is if you look at the arrangement at the time, the arrangement is defined as follows. The arrangements for the surrender of fugitive offenders means arrangement which are applicable to only applicable to these, the government and the government of a place outside Hong Kong. However, other than is the important part for today's discussion. Other than the CPG, the Central People's Government, or the government of any part or any other parts of the People's Republic of China, which will include Taiwan or local governments of the PRC, so and Hong Kong and place outside Hong Kong other than other parts of PRC. So basically the arrangement continue the old law back to April 1997, which exclude the application of this arrangement to any part of mainland China. So why are we sitting here today if on the face of Taiwan is not included? Obviously, if we look at Chapter 1, which is Section 3 of the Interpretation and General Courses Ordinance, PRC is being defined as including Taiwan and any special administrative regions in Macau, Hong Kong administrative region and Macau special administrative region. So defined this way, it means that one cannot send a person back to Taiwan under Cap 503 because the other than the CPG part or the government of any other part of the PRC. So these exclude the possibility of sending any person to Taiwan or mainland China or Macau, if Macau interests you. So this is the situation. So if we look at the Bills Committee's debate, we may not have a Bills Committee this time, but at least back to 1997, we do have a Bills Committee discussing this Fugitive Offenders Ordinance at the time. So there was a Bills Committee being set up at the time, and the chairman, Mr. James Toh, he was the chairman at the time. He obviously is no longer the chairman, or I don't know whether he's still a chairman now, but anyway, he claims still to be the chairman of the House Committee. No, the Bills Committee. The Bills Committee, of course. So the chairman, Mr. James Toh, inquired of the effect of deleting the words in brackets other than the People's Republic of China or any part thereof. So he was asking, what will be the effect if we delete this? He was asking, how about we delete this? That means the arrangement will be applicable to all the governments and the governments of any government outside Hong Kong, meaning including Taiwan, the mainland China, and Macau, SAR. So that was the question posed by James Toh at the time as to the effect of deleting the red words here on this PowerPoint. The answer given by the then government, the Principal Assistant Secretary for Security, and also the Deputy Principal Crown Counsel from the International Law Unit, their reply is this: the purpose of the bill was to localize the then existing arrangement, which were UK-based and which did not include the PRC. To delete the said wordings would mean that the scope of the bill would exceed localization, and substantial changes had to be made to the bill, such as in respect of Clause 6 and 25. We can go to that later. But the importance of that remark is the matter of surrender of fugitive offenders between Guangdong and Hong Kong was being discussed separately, and there would have to be separate legislation to cover those arrangements. So the idea at that time is that, okay, don't touch that part because we are localizing the law at the time. Any transfer of surrenders between Guangdong, forget about the whole country, or just Guangdong and Hong Kong, we need separate legislation. We need to talk about it. Of course, 20 years down the road, there was no consensus or there was no agreement as to how those arrangements will be made, or anyway, the discussion seems to be very fruitful. So this was the background back to 1997. So, and that was the law. So currently, let's look at the existing 503, our law. We now, at the moment, we have about 20 jurisdictions having bilateral treaties with Hong Kong. We have 195 countries in the world. Only 20 of them have negotiated with Hong Kong for a bilateral agreement. And I'm sure that the International Law Unit and the Hong Kong government has been negotiating with other countries to increase the possible number of jurisdictions under the law. So under the existing law, if you look at the law itself, there will be long-term arrangement, and you will see that we have two arrangements under the law. One is the long-term arrangement, where we have 20 countries, 20 jurisdictions signing bilateral agreements with Hong Kong. So this is the long-term bilateral agreement signed by Hong Kong government with other countries. There's also a case-based approach. So apart from long-term arrangement, there's a case-based approach available under the existing law. Case-based approach is available based on negotiation of a one-off arrangement, but with one proviso. This must be done by subsidiary legislation before giving effect to the case-based arrangement. So the bill we are going to talk about today will be a creation of a third category of surrendering. The first category is a long-term arrangement between these 20 jurisdictions, the number of which can be increased whenever we have negotiated a long-term arrangement. The second one will be a case-based arrangement, which can be dealt with whenever a situation arises, but that has to be done through the blessing of the legislature. The existing bill, the bill which is now being proposed, seeks to create a new mechanism for case-based surrender without legislature's intervention or supervision or scrutiny. And that will apply to the mainland China, Taiwan, Macau. Okay, because you understand that from the case-based approach, it applies to all the countries, all the jurisdictions except the PLC, including Taiwan, and Macau. So the new creation is a one-off case-based arrangement in which you do not need to go through the legislature. And the main target will be obviously Taiwan and mainland China. If you want to send a person back to a country not included here, the second option has already been there. It has been there since 1997. Pausing here, I would like to go very quickly to the existing procedure for surrender. I would like to very briefly introduce to you what is the operation of the existing surrender procedure. You see, when there's a long-term arrangement, surrender arrangement, there are basically three stages. The first stage is the CE. Under the long-term arrangement, issue a document which is called authority to proceed. So she or he, depending on who is the CE, will issue an authority to proceed pursuant to a request from a country, from a jurisdiction. Then the matter, then he'll be arrested by an arrest warrant. I will go to that later. And then we move on to a committal proceeding before a court in a magistracy. And after that, the CE will then make an order for the surrender of the fugitive. So one of the procedures is an arrest warrant may be issued by the court by a magistrate. In normal cases, after an authority to proceed has been issued by the CE, so the court, having received this authority to proceed, issue a warrant, or actually, which is very often the case, in urgent cases, and most of the cases are urgent cases, a provisional arrest warrant could have been issued even before the CE has issued an authority to proceed. So under the existing mechanism, in urgent cases, the Interpol would go to court and apply for a provisional warrant and then arrest that person, and then they go to CE to ask for an authority to proceed. Then the mechanism will start from here and then go to the committal proceedings. So a person arrested pursuant to a warrant, either a formal warrant or a provisional warrant, shall be brought before the court ASAP, as soon as practicable. But there's a presumption against bail. That is an interesting part. There's a presumption that bail should not be granted. The law assumes that if you are a fugitive, you can't be given bail unless you can prove exceptional circumstances under which bail will be given. I've been in this area of law for long enough. I have never been able to get bail for all my clients or any of my clients because by definition, he or she is a fugitive. When he's arrested, there won't be any exceptional circumstances which will allow one to be given bail, okay? Or, of course, this has to be argued. Whether one can argue whether it's compatible with the basic law, Article 5.3. I argued it, I think, 15 years ago, without success in the magistracy courts. I didn't take the matter further. But anyway, there's a presumption against bail. So the procedure is this. The procedure is that a warrant will be issued. Okay, a person will arrest. That person will be brought before the court. And the court will lock him up, basically, without any bail being granted. Then we move on to the committal proceedings. So in the committal proceedings, there's not much one can do. I will demonstrate to you later, but this is procedure. And the long-term surrender procedure is not too much different from a case-based procedure under the existing law. Under the existing law, the only difference is that in a case-based surrender, the Legislative Council has to scrutinize this case-based surrender. And then from there, we move on to the CE and then committal proceeding and then order for surrender. So there will be an extra step to be debated by the LegCo. This procedure is to cater for case-based surrender. We don't have time, but we can go into the detail of it, if necessary in our discussion section. But so this is basically the situation. The next point I would like to mention very briefly is that under our existing law, there are some restrictions on surrender. For example, the law must be criminal in both sides, so it means double criminality. No offense of political character can be surrendered. Conviction obtained in the absence of that person may not be able to be surrendered. I noticed that Mr. Wong is over there. He is representing Mr. Lau. He was convicted in Macau in his absence. So maybe he might be able to make use of this section to resist any surrender request. I'm sure that he knows. We can ask him about that later. And also there's restriction on prosecution on the basis of race, religion, nationality, or political opinion, or previous conviction or previous acquittal. So these are the restrictions on surrender. And you also know the concept of non-resurrender. If you send one person back to country A cannot send him to country B unless you give him a chance to leave country A, okay? And also specialty, you wanted him for murder, you cannot trial him for a rape offense, okay? So these are basically the procedure. But as I mentioned earlier on, the most important part is the limited role of our court in Hong Kong in the committal proceedings. So after an arrest warrant has been issued, the Interpol go and arrest a person and then bring that person before the court ASAP. And then there's a presumption of no bail. And then what the court can look at in the committal proceedings is very limited, as indicated in those cases which I, one way or the other, have been involved in back to 1997, 1998. In this Chang's case, the court clearly says that it is not within the jurisdiction of the magistrates, nor is it his function to receive evidence concerned with the obligation under the treaties. His powers are limited to those provided for in the relevant statutory provision. What does it mean? It means this. In Chang Cui-ping's case, Chang Cui-ping was also quite a famous case in which you will note that Professor Rogers VP was actually the judge. Rogers VP is one of our former bar chairmen who has recently co-signed the press release issued by most of the former bar chairmen. So Vice President Rogers, Mr. Judge Rogers, in this case, in Chang Cui-ping's case, Chang Cui-ping is a case known as Yang Se Wang Hao at the time because she was responsible, she was alleged to be responsible for importing those illegal immigrants from the mainland to United States to work. So the court mentioned the matters to be considered by the courts of committal as set out in the law. It is unnecessary to set out the subsection, but it suffices to say that the matters to which the court of committal must have regard are, one, whether there has been a relevant offense, okay, whether there was an offense, murder, rape, as to whether the supporting document has been produced, whether the requesting country signed an affirmation, the document, asking for this person to be sent back, and whether those documents are duly authenticated. So they through their channels to authenticate the document. And that's it, right? Whether evidence produced would be sufficient to warrant committal for trial according to Hong Kong law. That means whether there's any prima facie case which will be sufficient to be commit a person to the court of first in trial. So in another case, Keith J.A. mentioned, the court's function in these proceedings does not normally include assessing the reliability of witnesses. So when we receive a document from the requesting state, we do not assess the reliability of the witness statement. Although its function is to determine whether evidence would have been sufficient to warrant the fugitive's committal for trial if he was being tried in Hong Kong, that sufficiency is not normally dependent on an assessment of whether the evidence is true or accurate. So we do not look at whether the document, the evidence is true or accurate. Okay. Rather, the sufficiency of the evidence depends on whether the facts which the evidence tends to prove would amount to offense for which the fugitive extradition is sought. So basically, the court's role is very limited. You look at the document, if somebody signed on it, you do not query. You cannot query the accuracy. You cannot query the reliability. You can only see whether they have been authenticated, the document being sent, and then whether it will be sufficient to raise a prima facie case for the committal of that person. So in Section 23(4) of the law says, in any proceedings under this ordinance, any evidence which contradicts an allegation that a person sought to be surrendered under this law to a prescribed place has engaged in conduct which constitutes a relevant offense for which such offender is inadmissible. In short, any evidence which tries to contradict an allegation is not admissible. So that is the law, and that explains the limited role the court can play in committal proceedings. So in extradition proceedings, this is another case decided in 2002. In extradition proceeding, the examining magistrate only needs to decide if a prima facie case has been established. He cannot and should not attempt to foresee what, if any, defense will be raised and whether such defense will be successful. He will not be able to say that, sorry, I was set up, the police beaten me up, hence I signed that document, and this police was lying. All of these are not admissible, and it's not the function of the court in Hong Kong to investigate. So in deciding whether an order for committal should be made, the magistrate should not and cannot consider the possible defense of limitation period at all. So there's basically no defense. So this is basically what I have just gone through, Part A and Part B. Now I will pass the mic to Anson. Anson will talk to you about the new proposal and his understanding of the implication of the proposal. Having gone through the existing mechanism, having told you the background, the Taiwan murder case, then I will go back to our Part E later.
Firstly talk about proposals in the bill. You appreciate that there are actually many different aspects in the bill proposed by the government, but today, due to the time limits, we are focusing on the amendment to the Fugitive Offenders Ordinance aspect. You appreciate that there is another aspect in relation to the amendment to the mutual legal assistance in criminal matters legislation, but we will not talk about that part. Today we will focus on the so-called two problems set out in the Legislative Council brief for the bill. Here we use the word avowed purposes. Lawyers like to use the word alleged or purported, but today we would like to maintain a more neutral stance, so we will avoid those words, and we deliberately chose the words avowed purposes. In the Legislative Council brief or on other occasions, the Security Bureau or the Secretary for Justice or the CE have explained that there are two problems that they would like to tackle in proposing the amendments to the Fugitive Offenders Ordinance. The first is the Taiwan murder case, which Hector has briefly discussed. The second perceived problems is the so-called loopholes in Hong Kong's overall cooperation mechanism in criminal and juridical assistance matters. These so-called loopholes are twofold. Firstly, under the FOO, the other parts of the PRC, including Taiwan and Macau, are not included under the FOO regime. By definition, you cannot surrender a person to other parts of the PRC. So this is the first aspect of the so-called loopholes identified by the government. The second aspect of the so-called loopholes is that the government is saying that under the current ad hoc or case-based surrender arrangement, you have to go through the Legislative Council by way of legislative vetting. That means after the Chief Executive in Council receives a request for surrender from a jurisdiction with which the Hong Kong government has not signed any long-term surrender arrangement, there is an ad hoc request for surrender. Then the C in Council can make an order for an ad hoc arrangement. Then the order will be remitted to the Legislative Council for scrutiny. So the government is saying that this arrangement is impracticable or unworkable because in cases of request for surrender, if you have to debate it in LegCo or you have to gazette the order made by the CE in Council, then that will alert the suspect. Then he can go away or flee Hong Kong. But that perceived problem can actually be dealt with by way of the provisional arrest warrant just discussed by Hector. So these are basically the two perceived problems that the government proposed to explain why they need to amend the law by way of the current bill. And you will appreciate that this, the second problem, the second part of the problem, that the so-called loopholes has existed in the laws of Hong Kong, at least since the handover, for more than 21 years. But in the current proposed amendment, the government only held a public consultation for 20 days. So essentially, the government is trying to, or attempting to solve a perceived problem which has existed for more than 20 years by holding a public consultation for 20 days only. So, in dealing with the Taiwan murder case, we have to look at what is the response of Taiwan, because if you try to solve a problem by a proposed mechanism, but in fact that mechanism is not effective or not well received by the Taiwan side, then what's the so-called purpose? That means your means cannot justify your ends, because your means simply cannot achieve your avowed purpose. So this is what the Taiwan side said, as reported in the Hong Kong Free Press. Taiwan has undermined the need for speed by confirming it will not ask for Chang's Chen Tonggai, that means Chang's return, because it is concerned that Hong Kong's extradition law puts its people at risk of being snatched by China. And without removal of threats to the personal safety of Taiwan nationals going to or living in Hong Kong caused by being extradited to mainland China, we, meaning the Taiwan authority, will not agree to the case-by-case transfer proposed by the Hong Kong authorities, set by the Deputy Minister of Taiwan's Mainland Affairs Council on the 9th of May 2019. So that means the proposed amendment to the bill will not solve the Taiwan murder case problem, because the Taiwan authorities, if you pass this bill, Taiwan authorities simply will not make a request for surrender. So I will then move on to talk about the special surrender arrangements. As I said, there are other proposals in the bill, and we are today only focusing on the key proposals in the bill that are to differentiate case-based surrender arrangements, which is defined as special surrender arrangements in the bill, from general long-term surrender arrangements, and to stipulate that special surrender arrangements will be applicable to Hong Kong and any place outside Hong Kong, and they will only be considered if there are no applicable long-term surrender arrangements with the concerned jurisdictions. So essentially, if the bill is passed, it seems that there will be three types of surrender arrangements under the FOO, which Hector has briefly mentioned. The first is the long-standing, long-term surrender arrangements. The second one is the existing case-based or ad hoc surrender arrangements with legislative scrutiny, but which is not applicable to other parts of the PRC. The third new type of surrender arrangement is the case-based surrender arrangements without legislative scrutiny, but is applicable to other parts of the PRC. Here we use the word, it seems that there will be three types, because you may appreciate that it is not very clear from the proposed amendment whether the second type of case-based surrender arrangements will be abolished or what will be the legal consequence. You will appreciate that in the recent query by the legal advisor to the Legislative Council, Mr. Timothy Cho, to the Security Bureau, he also queried whether the proposed amendment will render the second type of case-based surrender meaningless or redundant. The answer from, I think is yesterday or the day before, from the Security Bureau is that the response is that in practice, The second type of surrender arrangement will, no one will use that mechanism, because in practice, the third type or the new type of case-based surrender is much easier, because you don't need to go through the Legislative Council. That means only the Chief Executive will be able to enter into the arrangement without going through the legislature. This is the new Section 3, capital letter A, as proposed in the bill, that provides for a mechanism under which the Chief Executive in Council can issue a certificate. And if the certificate states the following matters, it will be conclusive evidence of these matters. That means one cannot dispute these matters in court. The two matters are first, there are special surrender arrangements. Secondly, and in respect of the person, the procedures in this ordinance apply in the case of the place outside Hong Kong to which the arrangements relate. And this is basically the arrangement, the special surrender arrangements under the new proposed mechanism. It starts with the Chief Executive issuing a certificate, which I just mentioned, and authority to proceed pursuant to a request for surrender from a foreign jurisdictions. And after that, the procedures are exactly the same as those existing procedures, which Hector has touched on. There are two noteworthy aspects in the new proposed mechanism. That is the applicable offences. Under the existing ordinance, there are 46 items of offences specified in Schedule 1 to the FOO, which are offences that can be subject to surrender, or in respect of which a request for surrender can be made, insofar as the treaty covers those offences. If the treaty covers less items of offences, then the relevant jurisdiction can only ask for surrender based on those items of offences. But in the new proposed arrangement, the government is trying to further limit the items of offences to 37 because of the concern expressed by the business sector. And the second noteworthy aspect is that the offences have to be punishable with imprisonment for more than 3 years, as opposed to 12 months in the existing mechanism. So these are the 9 excluded items of offences, and it is noteworthy that corruption offences is not excluded under the proposed scheme. And I briefly mention the implications of the bill. By implications, here we mean the legal implications, obviously not political or economic implications, because that is not within our expertise. And the first obvious legal implications is that any jurisdictions in the world, including any parts of the PRC, may enter into special surrender arrangements with the Hong Kong SAR. This is the first obvious implication. The second implication is that in practice, all case-based or ad hoc surrender arrangement will not go through any legislative scrutiny, or will not be subject to any legislative scrutiny, either by way of negative rating or otherwise, because the Chief Executive in Council alone can issue a certificate to activate the special surrender arrangements procedure. That means by the sole discretion of the Chief Executive, he or she can activate the new mechanism. And here is a table setting out the Rule of Law Index published by the World Justice Project in 2019. The purpose of showing this table is to illustrate that the new proposed mechanism is opening the possibility of surrender arrangement, not only to mainland China, but to those jurisdictions which have a worse legal system than mainland China, including some of the countries which are popular destinies for travels nowadays by Hong Kong people. So that may be a worrying aspect.
Right. I will use about a few minutes to talk about our alternative approach to solve the existing Taiwanese problem or Taiwan murder case if it is acceptable to the government. May I ask you to go back to page 43? If you go back to page 43, you see we have the long-term surrender arrangement being there for 20 years. We have the case-based surrender arrangement, which is available under the existing law with the legislature's scrutiny, but it is not applicable to the PLC, including Taiwan. What the government now is proposing is to add a third option, which is case-based surrender arrangement, but without scrutiny by the legislature. We believe in the public law principle that whenever you want to interfere with civil liberty, personal liberty, or liberty of movement, it must be prescribed by law. It must be censored by the legislature. So our first proposal is actually to amend the law here to include Taiwan. So if we go back to page to this page, you see my first proposal is so simple. One just need to amend the existing law, the definition of arrangement for the surrender of fugitive offenders. I read this to you, which are applicable to the government and the government of a place outside Hong Kong, other than the CPG or the governments of any other parts of the PRC, except Taiwan. So amending the law that way, it means it includes Taiwan. This arrangement includes Taiwan. So we will be able to, under the existing law, to sign long-term or case-based arrangement with the scrutiny of the legislature, and then we can resolve the Taiwan murder case for the time being. That can be done within a day. We can have 3 readings in the legislature, amending this part, adding just 2 words in the existing law. That will resolve all the problems in relation to the Taiwan murder case. That can be done very easily. So this is the first proposal. We are saying you just amend the existing Section 2.1 of the Fugitive Offenders Ordinance by including Taiwan. Then it will not cover mainland China nor Macau. Okay, so your clients also say, Mr. Wong, if you got a client from Macau. So this was the easiest way to resolve any difficulties facing the murder case. And we can use our time to talk about long-term arrangement between Guangdong and Hong Kong. We can talk about that for another 20 months or 20 years, if you like. Another option will be amending the existing law to confer extraterritorial jurisdictions vis-a-vis murder cases. We can extend our criminal jurisdictions of the Hong Kong court to homicide cases committed outside Hong Kong, in which either the suspect is a Hong Kong people, is a Hong Kong resident, or the accused is a Hong Kong permanent resident. That can also be easily done by amending the offenses against persons ordinance, which is a proposal by one of the parties in Hong Kong, or by amending the criminal jurisdiction ordinance, which is proposed by the Democratic Party. So at the moment, we do have extraterritorial jurisdiction in respect of certain offenses. So if you look at the existing Section 153P of the Crimes Ordinance, which confer jurisdictions on the Hong Kong court over sexual offense committed against children outside Hong Kong. So if the defendant, if the accused has Hong Kong connection, or the child has Hong Kong connection, so that is not unprecedented. That is already there in Hong Kong. So, for example, this law provides that a person who is a Hong Kong permanent resident or who ordinarily resides in Hong Kong commit an act outside Hong Kong in relation to this sexual offense, you will be guilty of an offense which can be tried in Hong Kong. Or alternatively, any person, no matter who he is, commit any act outside Hong Kong committed in relation to a person who is a Hong Kong permanent resident or who ordinarily reside in Hong Kong. So either the accused is Hong Kong people or the victim is Hong Kong people. In relation to some sexual offense, we already exercise jurisdiction without any difficulty in Hong Kong. What we need to do is add murder. Just murder. Don't add manslaughter. You may not want to add corruption, but just deal murder because you want to deal with the Taiwan murder case for the time being. In fact, this extraterritorial jurisdiction on murder is not unique in Hong Kong. It is actually acceptable in all the jurisdictions, including the mainland jurisdiction. Professor Hualing is here, so I don't want to bang Hualing Fu, but I just said this criminal law provision in which I think we're all familiar with. So this is Article 7 of the criminal law of the PRC, which says that this law shall be applicable to any citizen of the PRC who commits a crime prescribed in this law outside the territory and territorial waters and space. So that is one aspect. Another aspect is that this law, Article 8, may be applicable to any foreigners who commit a crime outside the territories of PRC but against a resident or citizen of the PRC. So similar. Either a person who commit a crime outside PRC or a PRC resident who commit a crime outside the PRC. So these are not unique. In fact, if you look at our common law jurisdiction, which is also applicable in Hong Kong, for example, the Coroner's Court. I think most of you will remember this case, which I did back to 10 years ago. This is the Coroner's Court in Hong Kong, who conducted a death inquest into the hostage instance which happened in the Philippines, where 8 Hong Kong residents were killed on this bus. So under Part 1 of the Schedule 1 to the Coroner's Ordinance, any reportable death, which include any death of a person who occurred outside Hong Kong, but when his body was brought back to Hong Kong, the Coroner's Court in Hong Kong can exercise jurisdiction. And in this case, I represented one of the victim's family. In this case, the Coroner's Court, with a 5-member jury, it was actually a jury trial, a 5-member jury, in which they heard evidence from 31 witnesses from Hong Kong, and what's more, 10 witnesses from the Philippines. We did through video link, we hear evidence from the Philippines, and later on, after hearing all the evidence, the jury returned a narrative verdict for the first time in the Hong Kong legal history. And then they found all the 8 victims were unlawfully killed in the Philippines. So this is a situation where we have Hong Kong court with a jury trial determining whether a person was lawfully or unlawfully killed in another country. The last remark which I want to mention before I pass back the mic to Professor Yang is this. If we look at the UK Human Rights Act, the Extradition Act 2003, there was actually an express provision which allow a judge in an extradition hearing to consider whether the requested person's extradition would be compatible with the rights guaranteed by the European Convention on Human Rights. So a judge, in deciding whether to surrender a person, they would determine whether the person's extradition would be compatible with the convention rights, which was guaranteed under the European Human Rights Convention. And there was actually a real case in 2017 in which the court refused to surrender a request from the government of Rwanda seeking extradition of a person back to Rwanda for trial for killings committed in 1994. The court hold that there was a real risk of this respondent suffering from frequent denial of a fair trial. So the court mentioned that, well, because the judicial independence is weak, the state is not very democratic, basically, and refused the request. there was another case which, there are actually more than one case in which the court in the UK refused surrendering. The question, of course, apart from my three proposals, another way to deal with the matter is to import such a provision into our bill. But the question is, do we really want the Hong Kong court to ask to decide similar question vis-a-vis a request from the mainland China? So this is also a difficult question which we can discuss. So with that remark, may I conclude my presentation, our presentation, pass the mic back to Professor Yang and Professor Fu.
All right, well, thank you so much, Hector and Anson, for your very clear presentation and the helpful slides as well. I think we all learned a lot from that. At this point, I'm going to turn to my colleague, Professor Fu, to give his comments on the topic.
I'll be very brief. Two short comments on Hector's very comprehensive presentation. One is, I think you said during your presentation, said we debate on this issue for over 20 years, and that we can't debate for another 20 years, and then let's see. So first half, now we're 23 years into this one country, two system. We didn't achieve anything. So we're basically repeating history, doing whatever we used to do, and we'll just continue to do it for another 20-some years. Then, of course, there we are, 2047. Then let's solve the difficult issues. So I'm not sure whether that is a good answer to the difficulties we are facing. The second comment is there are lots of solutions. Even those solutions answer the difficulties we are solving, difficulties we are having, but then they may create additional problems. For example, if you extend the jurisdiction in murder case, for example, someone, let's face it, our difficulties is mainland China, right? We're not really worried about Taiwan or anything else. So it is the mainland. Say, if a Hong Kong person went to mainland, murdered someone, and come back to Hong Kong, the solution is, okay, we don't extradite that person to the mainland because we don't trust the system, so we try out that person in Hong Kong. But then, of course, all the evidence would be in the mainland. You have to trust the evidence gathering process of the mainland. I'm not quite sure whether, for example, police officer will come across the border to Hong Kong to give evidence. At the end of the day, then you have to face the difficult issue how to deal with the mainland legal institutions. Somehow, my impression has been that we've been trying to avoid, try to hide, so that the problem, the difficulty would somehow disappear. So I'm not quite sure that would be the solution. Maybe at a certain stage, we just have to face the issue, just have to bite the bullet. That is the difficult question. We cannot run away from it. So now, let me just introduce another case which I think is highly relevant. It's a New Zealand case decided in 2017. Mr. Kim, K-I-M, a South Korean citizen, New Zealand resident, who worked in Shanghai in 2009, and there he killed his girlfriend, and then he ran back to New Zealand. So that's the case, right? A South Korean citizen killed someone in Shanghai, went to New Zealand. China, of course, requests extradition from New Zealand. So that's the nature of the case. Like Hong Kong, New Zealand does not have a treaty with China, but New Zealand has an extradition act, which announced ad hoc, one-off extradition. So China write to the Minister of Justice, the Ministry of Justice in New Zealand decided to extradite the person to China to first murder trial, So the case is a judicial review of the decision of the minister. Right? Hector is perfectly right. In the extradition proceedings, judges don't really look evidence closely. China said he was the suspect. There was fingerprints. There was a witness statement. There was a non-serious telephone conversation indicating that there will be prima facie evidence that he was the suspect. But then Hector probably underestimated the role of courts in the second part. The second part is in the extradition proceedings, the court actually look at the Chinese criminal justice very closely. It has become a standard practice in all the Western courts when China requests the return of a fugitive offender, the court would look at three things very closely. First, death penalty. Right? Chinese answer to it is China would give assurance that that person would not be executed, and that has been widely accepted. The second issue is torture. Right? Torture, of course, is perceived to be a serious concern in China. The issue is whether the person, if sent back to China, would be tortured in the interrogation process. The court went spent many pages on that particular issue. Then a combination of factors, the court decided the possibility of that person to be tortured back in China is very small. So it's basically safe to send him back to China. There are many, it's an interesting case. I would advise interested people to read the case, there are lots of details. Finally, is the issue of fair trial. Right? Does China has a fair trial, or would the Chinese criminal justice system be able to offer a fair trial to that particular individual? Right. Again, there was lengthy debate on that issue. At the end of the day, the judge decided, right, there will be no death penalty, there will be no torture, but the judge did not have faith that there will be a fair trial in China. So he quashed the decision with the minister and asked the minister to reconsider the decision. A few months later, the minister reconsidered the issue and decided to send the person back again. Of course, then there is the second Kim number 2, the second judicial review of the same case by the same judge. After a few days deliberation, the judge decided, he changed his mind. The reason he changed his mind is mainly China gave multiple assurances. Right? China gave a number of guarantees. Basically, China guaranteed supranational treatment for that particular suspect. Now, I think New Zealand law, Canadian law, on extradition, repatriation of fugitive offenders are not that different from the proposed bill as far as law is concerned. The difference is Hong Kong is different. Hong Kong is different from Canada. Hong Kong is different from New Zealand. I think it is for us to figure out what exactly are the differences. Right? If the resistance to the proposed bill has any validity or legitimacy, I think we just have to look at argument that is beyond the legal argument. I think lawyers have done a wonderful job. I think it is for the society, the community, to think more closely as to who we are and what do we want for now and for the future. Thank you.
Thank you very much, Hualing. So in view of the time, and I want to save some time for Q&A, I just want to make sort of 4 brief points. Just a very quick point. I think one of the suggestions, Hector, is that we should have extraterritorial liability for murder. I think the response I would have is that, of course, that wouldn't work for Chang's case because it would involve retrospective application of a new law, and I think that would have serious Hong Kong Bill of Rights problems. Yes, you may try to argue for an exception, but I don't think that's really a good way to go, because non-retrospective criminal laws is usually regarded as one of the fundamental rights, absolute right. So it'd be very disingenuous to try to solve this problem by trying to argue for an encroachment on that right. The second point is you showed us Articles 7 and 8 of the Chinese criminal law. But you didn't, I thought you were going to, but I thought what you didn't do in your presentation is to show the wider implication of those 2 provisions. Those are actually very significant provisions because China adopts a very broad policy of extraterritoriality when it comes to its citizens. And if you put that together with the fact that many Hong Kong permanent residents are also Chinese nationals under the Chinese nationality law, what it means is that if a Hong Kong permanent resident was to commit a crime outside of Hong Kong in a foreign state, which would be regarded as a crime under the Chinese criminal law, China could use this new mechanism to bring that person back to China to face trial. And that is, I think, a very significant implication of the reform. And I think, as my colleague Hualing was saying, it's implications like that that require us to really think about how Fugitive Offenders Ordinance, needs to be adapted for the intra-China context. Because, for example, under the current law, there is a power in the chief executive not to return a national of the People's Republic of China. Now that really doesn't make a lot of sense when you're talking about within China. So the question that arises is whether or not that power to refuse to send a national could be adapted to a power not to refuse to send a Hong Kong permanent resident intra-China. I know there's some legislators who've actually proposed that. I think it's a worthy safeguard to consider. It would parallel that safeguard that you have vis-a foreign states of not sending nationals. Now, the third point I want to make, just in reply to some things that Hector said about the limited role of the Hong Kong court. I don't disagree with the observations you've made. But let me just sort of, to put some balance to what you've said, to talk about a recent case that I was involved in. It was an extradition case, request from the US for someone in Hong Kong. I won't get into the facts, it's not important. But I want to just highlight that in our system, there are good safeguards that work. Firstly, you mentioned about presumption against bail. We actually tried to apply for bail for this person, and we brought a Bill of Rights challenge, which we won on the Bill of Rights point. We lost in the end. He didn't get bail. But that argument was accepted by the magistrate, that he said there was only an evidential burden. He read down that presumption to an evidential burden. But in the same case, what started out as a 15-charge indictment from the US, firstly, and I think this is important, you have to give credit to the Hong Kong government and their prosecutors. They brought it down to basically 11 charges. They looked at the evidence closely, and there are things that were in that indictment which were just, far-fetched. And the government lawyers were able to bring it down already when they brought it before the magistrate. And then through the process, we didn't argue any of the human rights grounds, but we argued basically prima facie, looking at the evidence very closely. And we were able to take that list of 11 charges down to 4 charges. And so he was committed on 4 charges. So there are some safeguards that are working there in that case. The fourth point I'd like to make is about legislative scrutiny. I think it is a worry that we are moving towards a regime now where there won't be any legislative, and also there won't be any scrutiny by the Executive Council either, because one thing you didn't mention is that the existing scheme requires that the Chief Executive in Council look at the matter first, that it's debated in EXCO, and then it's sent to LegCo for approval. So some of you may have read an interview I did with South China Morning Post. I see the author of the article is here, where I propose that maybe we can bring back legislative scrutiny and in a kind of fourth model, or we change the government's third model, whereby after you arrest the person, you have to go back to LegCo for basically endorsement, or it has to be vetted in LegCo again. I haven't heard a lot of discussion of this. I still think it's a worthwhile safeguard that should be discussed. And in a way, you know, what we're seeing in LegCo now basically is legislators who are concerned about many things, but one thing that they're concerned about is that they're giving up this power of scrutiny in these types of cases. So maybe by having this safeguard, they can sort of regain some of that power back. All right, so I'll leave it at that, and we have about almost 15 minutes for Q&A. Let me ask our main speakers, is there any reply to our comments that you want to begin with?
Not really a reply, because you know that these two professors sitting on my right are actually my mentor and my role models in the past so many years, and I learned a lot from them. So I was not able to argue with them, honestly. Well, if you allow me to say this, I think the first point which was made by Professor Fu is how many years do we want to wait? I can only emphasize page 6 of my PowerPoint about the reciprocal arrangement concept, because all these bilateral treaties are two parties, like getting married. You need to negotiate with both parties. You cannot say just unilaterally implement one scheme without the acceptance of the other side. And the next point mentioned by Professor Fu is the New Zealand model. Of course, the New Zealand model is quite similar to the UK model, which I mentioned, page 64 of our PowerPoint. There's actually an inbuilt law which says that the court can look at the human rights situation before one can be surrendered. It is required. The judge is required to look at it. So the New Zealand model is quite similar to the UK model in the sense that the court can determine. And I have asked that question whether we want our court to look at this issue. But anyway, this safeguard is missing in Hong Kong. So if there's such a safeguard, perhaps people will be, perhaps the proposal will be more acceptable, because at least we got the court as the final safeguard for it. And another point is page 18 of my PowerPoint is when we look at the existing proposal, it means the government of any part of the PLC can do it. And of course, it might refer to Taiwan, but it can also refer to a provincial government or a government of a city or a county, we don't know. It's just that there's no detail about the proposal. So what levels of government can make such a request to Hong Kong, and where that person surrender will be trialed? Is it in Beijing? Is it in Xinjiang, Xizang, or some other rural area of the PLC? So these issues have not been reviewed by the administrations, as if a Hong Kong permanent residents had been surrendered back to face trial in the mainland, where will that trial be taking place? So these all are the issues which we need to look at. And lastly is the retrospectivity issue mentioned by Professor Yang. My reading of section 12, article 12 of the Bill of Rights Ordinance is this: no one shall be held guilty of any criminal offense on account of any act or omission which did not constitute a criminal offense under Hong Kong law or international law at the time when it was committed. So my reading is that, like the government's reading, right, you can send, after the pass of the law, you can still send Mr. Chang back to Taiwan to face a murder trial. because murder has always been recognized as a crime in Hong Kong. So there's no question of retrospectivity. It's not like speaking foul language yesterday, it's not an offense, and tomorrow it becomes an offense. So murder has always been a criminal offense in Hong Kong and in Taiwan, and I think in all countries in the world. So we may not have this difficulty of retrospectivity, especially when you look at sub-article 2. Nothing in this article shall be prejudiced the trial or punishment of any person for any act or omission which at the time when it was committed was criminal according to general principle of law recognized by the Committee of Nations. And if you look at the Chinese translation, that is actually quite clear. 任何人之行為或不作為，於發生當時依各國公認之一般法律原則為有罪者，其審判與判刑不受本條例之影響。And of course, you need to look at 1 and 2. So my reading of it is that murder has always been recognized as a crime in Hong Kong and internationally. Of course, I think it's subject to argument, it's subject to debate as to whether it can be done. But if my proposal cannot be done, the government's proposal cannot be done either, because you are sending a person back to Taiwan when there was actually no arrangement between Hong Kong and Taiwan, which was possible. So I think that is all what I want to sort of discuss with Professor. And this takes me to my conclusion. If you go to my conclusion, in fact, I was saying that, well, this is a big topic which has been discussing for 20 years. So we do not try to resolve these two problems, the Taiwan murder case and the so-called loophole, by this bill, when we only have 20 days of public consultation, which try to resolve a problem which has been lasting for 21 years. And one of the proposals proposed by us is that perhaps this matter should be referred to the Law Reform Commission and ask them to speak up their process and talk to the counterpart in the mainland China and to see whether we can come up with a mutually acceptable bilateral arrangement.
Thank you very much. All right, can I see if anyone has any questions? We'll take a handful of questions and then we'll send it to the panel. Yes, this gentleman. Please, if you could be brief, because we really don't have a lot of time.
Question in two folds. First one is, it all boils down to the possibility of the government, the CE, signing surrender order at the end, right? Mm-hmm. So is this surrender order being an administrative act subject to judicial review?
That's easy to answer. Yes, the answer is yes.
Yes,
yeah.
And the second part is, when the court discuss or scrutinize this particular surrender order, is it not implied that human rights safeguards would be a question that the court would explore anyway, with or without that New Zealand model in there?
Okay, so human rights safeguard. It's another question? Yes, brief, please.
In regards to mainland China and saying we will not execute someone, can you really trust what they say? I mean, there's not much transparency in China. Does anybody here know how many people get executed every year? It's been very difficult for me to find out.
Okay, can we trust the assurances? All right. Number 3, any third question? Any other questions? Wants to raise? Yes, please. Do you want to use the mic? Press the button. Use the microphone.
Yep. I would like to ask, how does the retrospectivity comes into play when we are not creating new offences? We are just conferring jurisdictions on to try an offence which the court could not try before. Yeah. How does it come into play?
Okay, good question. We'll answer that. Any more questions? Yes, Alvin?
Sorry, a two-part question. One is, I noticed in the UK, the murder has always been had somewhat an extraterritorial effect. The UK court has to it. Why is it not being written into Hong Kong law in the first place? Another question is, it seems from the reading of the Bill of Rights, the very fine difference lies in whether the murder has an extraterritorial effect is technically extending a little bit. But is there a way to get around by admitting, okay, this is something exceptional, where the legislature would pass something that, under exceptional case, this is something that applies only in this limited scope. Thanks.
Okay. One more question. Anyone else want to ask the last question? Okay. If not, then let's turn to the panel. So the first question, if I understand it correctly, is even if you judicially review the chief executive's decision, could you not also argue human rights grounds? So that's, I think, a question for you, Hector.
Well, I actually do not want to commit myself for obvious reason. In the past, the court said no, all the considerations are there in the law already, right? As to whether in the future we can reopen this issue, as to say, well, when the CE signed this order for surrendering, the CE should look at these factors. In fact, these are also my comments in some other manner as to, at the moment, we do not have a criteria being set out in the law as what are the criteria the CE will look at before the CE actually sign the order surrendering that person. People will have more comfort, or the society will have more comfort, if all those criteria have been set out clearly in the law, saying that, well, when the CE signed it, the CE need to look at the human rights situations before she actually signed it. And if, when one judicially review the decision of the CE to sign it, you can trust the CE by saying that, well, you didn't look at the human rights situation, or if you have looked at it wrongly. But at the moment, it seems to me that the existing law does not allow us to do it, but I would like to reserve my position for obvious reasons.
Let me just add to that, yeah, I think the legal position is a bit unclear right now to what you can argue in a judicial review of the CE's decision. But many of these agreements with other countries, there is in those agreements a ground to refuse on the grounds that it is oppressive. And so, the courts have said that you can raise that with the chief executive, that it's oppressive.
There are basically, we have 20 jurisdictions. There are, I think, 3 or 2 orders which specifically mention these matters, but not all of them. Yeah.
Yeah. Right. Hualing, can we trust assurances?
Penalty.
Well, that's a big question. That's penalty, I think China has made concession in treaties not seek extradition if death penalty is applicable. So in treaty with Spain, with France, with Portugal, the proposed treaty with Australia, China made a firm commitment that death penalty would not be an issue. It's difficult to say. In 1995, there was a big scandal, I mean, no clear evidence that China may have given and taken to Thai government not to execute someone, but then after extradition, execute that person. But then there's debate whether China did give the assurance in that particular case. But after a few years, most of the countries tend to accept China's undertaking. Start with Canada in the smuggle Nanjing's case. Japan did, US did, the South American Human Rights Court did, accept China's undertaking, and most recently New Zealand court accepted. So I guess most of the country wouldn't be facing that particular question. They would not always doubt. If we read judgment, there's always a doubt there. But then, on balance, the court tends to say, okay, we accept. Of course, there will be mechanism to observe. Right? Most of the embassies would have the burden to do the periodical visits in prison to see that person has been tortured or the person is still alive. So there is the mechanism to make sure that China would be faithful to its own commitment.
Still remember Canada sent back Lai Chern-Sing with an assurance. Does anyone know if he's still alive? Is he? You know?
I think as I said, there's the burden because the embassy, Canadian embassy in China would have to visit him once every 2 months.
Yeah. All right, now we have a few questions about retrospectivity. Maybe I can take this one about retrospectivity when it comes to substantive criminal law and retrospectivity when it comes to procedural matters. And I think that is a very important distinction. This is where I would disagree with you, Hector, because I think retrospectivity as to the extradition arrangement is a procedural matter, and that's fine, because, I mean, the crime of murder was always murder in Taiwan. But I do think that extending the territorial scope of murder alters the substantive law of murder. And that, I think, is a problem for the Bill of Rights. The last question, if I understand it, Alvin, correctly, is the history about why wasn't murder made extraterritorial in Hong Kong, although it was always extraterritorial, or not always, but it was extraterritorial in England for many years. And I think the history behind that is, I don't know 100% sure, but I think that the policies of extraterritorialities for the colonies was very different from the home jurisdiction, from England itself. And that I think England would control to the extent to which the colonies would have extraterritorial power. Right? And so I think the thinking behind it is that if there was an extraterritorial crime of murder, then that person could be tried back in England. So I don't know all the history behind it, but I think that's what I've read about it. I don't know if any other panel members know about that. Do you know about that?
Just on the first question, in fact, the Secretary for Justice, Teresa Chang SC, has committed the government in a public press conference that the court will look at human rights conditions if the bill is passed. But you may wish to note that this cannot create a legitimate expectation if the law properly construed does not confer you that right. So that is a statutory construction question. But if the bill were passed and there's a suitable case, we will fight that point by citing Teresa Chang SC.
Okay. Hualing?
Just to follow on that, I think that really is my concern on this debate is with either and or, right? Is it possible, for example, we just pass the law to have a built-in human rights mechanism if you are not confident, right? So you say the CCPL apply whatever human rights mechanism will be applicable in the proceeding. If they think the list of offenses is too long, we could shorten the list, right? We could limit it to murder or serious offenses against the persons, but nothing else. That I think probably will be a more feasible proposal, and it is also more constructive.
Yeah. Okay. Right. Of course. Final word? No. Anyone else? Okay. I think in view of the time, we've gone over the time by 5 minutes. Let me now say thank you very much to our speakers today. Okay. And thank you all of you for coming. Actually, 我做第二個 extra 錄完10個禮拜10日就係我都會有一件。係啊。